You won't believe the chaos that unfolded in this intense courtroom drama. Janelle Anthony, a woman facing serious assault charges and allegations of racially motivated hate speech, completely lost control during her arraignment. What was supposed to be a routine court appearance quickly turned into a shocking spectacle as she screamed, yelled, and erupted in emotional outbursts at the mere mention of jail. Her behavior was erratic, unpredictable, and at times frightening, leaving the judge and everyone in the courtroom struggling to maintain order. As her attorney raised serious concerns about her mental health, possible drug influence, and whether she was even competent to stand trial, the tension in the room kept building. Anthony faces multiple severe charges, including assault with intent to commit great bodily harm, resisting a police officer, ethnic intimidation, and assault and battery, and the gravity of these allegations only added fuel to her explosive behavior. From questioning the validity of her arraignment to demanding special treatment, her actions revealed a complex mix of defiance, fear, and possibly deeper psychological issues. The judge expressed concern about her mental state, the availability of proper mental health services, and the challenges of protecting both the public and the defendant herself, highlighting just how difficult the justice system can be when faced with extreme cases like this. Every moment of this hearing was tense, shocking, and unforgettable, exposing the raw, chaotic reality that can unfold in court when anger, fear, and legal pressure collide. You won't want to look away from this jaw-dropping, viral-worthy courtroom showdown that has everyone talking and questioning what justice really looks like in moments of utter chaos.
Good afternoon. Miss Anthony, can you hear me?
Yeah.
Okay, this is Judge Middleton.
Hi.
Hi, I wanted to talk to you. I've got a bunch of people here at the court with me. Mr. Keith Stickley, the Chief Public Defender, is here. Your attorney, Mr. Ross Truckee, is here. And prosecuting attorney David Marvin is here. Janelle, I don't know if you remember me, but I remember you from when you were.
I know my dad. I went to school with your son Alex. He was
yes, I remember.
He was a good boy. I liked him.
Well, thanks. He's still a good boy. He just turned 40. All right. You're charged with some very serious charges.
Yeah, they were
assault with intent to commit great bodily harm, resisting obstructing a police officer, ethnic intimidation, and 2 counts of assault and battery. The magistrate set the bond in the amount of $10,000 cash or surety, and Mr. Truckee made a motion, and he wants me to review that bond.
Thanks, Mr. Truckee.
Your Honor.
Yes.
I had the opportunity, sorry to interrupt, I had the opportunity to review the video from yesterday, the arraignment. And the same sort of thing that happened yesterday from my point of view is happening now. I don't know if she's aware of what's going on as she sits there. I don't know if she's on the page. I don't think she heard a thing he said. And I know anytime anybody can make a motion for competency, then I would suggest that she assess for competency.
All right, Miss Anthony. Janelle? All right. Janelle, I'm going to let you go back to your cell. Brandy, you can take her back. All right, thank you. Well, that did not go well. Started all right. David, I don't think you helped anything. I was establishing some rapport, and then it all sort of went sideways. But
I don't agree, respectfully.
Well, I guess you don't have. I had given the floor to Mr. Truckee to make his motion, and you said, I don't want to interrupt, and then you interrupted.
Your Honor, may I say something else?
Yes. I
was looking at the computer screen. I don't know what you were looking at, but I saw somebody who had her head turned away from you and did not hear a word you said. And I don't know if you're looking at the
I saw the same thing you saw.
I would like to inquire, Mr. Marvin.
All right, well, first of all, let's back up. You made this motion I'll read it. You don't cite any authority. You just made a motion. The reasons for the modification of the bond are failure to effect a proper arraignment on the defendant within 48 hours. There exists an unreasonable delay due to the ill will of the custodial officer during the arraignment hearing. The defendant was under threat or coercion during the arraignment, and the officer's actions jeopardized her constitutional right to make statements freely. Magistrate Autumn Kiefer probably was doing the same thing I'm doing, trying to do the best she could. And the unreasonable delay is not unreasonable because the delay is due to the mental illness of the defendant. And Mr. Marvin, I think, is on the money that we need to probably have a competency evaluation sooner rather than later. So, Mr. Truckee, what were you asking me to do?
I was asking you to find that the arraignment that was offered and is being tendered as an arraignment within the 48 hours was not a valid procedure, not due to Miss Anthony's unruly conduct or mental illness, but due to the conduct of the corrections officers that were present in the holding room with Miss Anthony. Twice the taser was directed at her head.
Well, look back up. What's your authority for this?
Under MCL 764.13, 764.26, and People v. Cipriano all address the need for this 48-hour period. And it's United States and Michigan constitutions.
All right, well, let's take yesterday off the table for a minute. I just attempted to do an arraignment myself. The bailiffs were gentle with her. She was okay for a minute, and then she disassembled before our eyes. So whatever just happened was not as the result of conduct of the corrections officers. I asked the officer how she was doing. They said she was calmer today, but she had been crying all day. She's obviously suffering from severe mental illness. Problem in today's world is we can't tell how much is mental illness and how much is methamphetamine or both. The current configuration of methamphetamine helps create schizophrenia. So I don't know if that's what we're dealing with or she just is schizophrenic. The charges are very serious. Assault with intent to do great bodily harm. The booking information indicated that she jumped on some lady's back and broke her collarbone and said a bunch of racially charged hate stuff and fought with the officers, and it was a bad situation. So what you're asking me to do is essentially give her a PR bond or just discharge her?
I'm requesting that she either be granted a PR bond in this case with the understanding that she's on bond in a circuit court case, and that PR bond may not mean her immediate release. But I think in this file, she was denied due process by failing to be arraigned and failing to be afforded the ability to meaningfully participate, even though her participation isn't going to be terribly meaningful. A taser was aimed at her during the arraignment. She was directed how to answer the magistrate's questions. And I don't think that in any way that can be found to be an effective process.
All right. Well, the one we just did was she's posted bond in the circuit court. As far as I know, there's been no motion to revoke that bond. I don't have the authority to revoke it. She's pled guilty, so she's no longer presumed to be innocent, so she's not entitled to a bond, but she has a bond and she posted it. She pled on the 24th of September, and this incident occurred on September 30th. So I'm not sure what happened between the time she pled in circuit court and the time she got arrested in Three Rivers.
I would indicate, Your Honor, I'm in possession of a complaint regarding her conditional release from Officer Dibble. Due to this alleged conduct, he's seeking that in a circuit court case, and it's suspected it would be dealt with promptly.
All right, well, I'm going to deny the motion for PR bond.
I did have an alternative request, if Your Honor would hear it.
All right, what's your alternative?
It may be based on the conduct during the arraignment, request that she be held at a different facility pending trial. It appears that it's unsafe for Miss Janelle Anthony at the jail.
All right, so you make an oral motion on the fly for me to remove her from the jail. So I'm not going to grant that either. I don't know. I have faith in our jail staff. I know all of them. I knew the two ladies in the video. I don't know what happened yesterday. I know what I just saw. But the fact that we're going to get a competency evaluation is going to greatly delay this. And she's going to be sitting there. So I don't know if there's any evidence that she's being mistreated presently. I did talk to the undersheriff about her yesterday, and a couple issues. For the last several years, we've had Covered Bridge as our mental health liaison, jail diversion specialist at the jail. That contract ended September 30th, and a new contract began with Pivotal. And frankly, we've had some bumps in the road. I had asked someone for some help with Aaron Brown, and I made 2 requests last week with no response. Got a response on Lisa's last day, September 30th, and then I sent an email to the director of Pivotal saying, will someone please help me with this guy? He's sitting in jail and he's got some serious mental health problems. And I haven't heard anything back. So right now, mental health is Pivotal, our county mental health. She was apparently capable enough on September 25th to enter a guilty plea I guess it was no contest plea in circuit court, and Judge Stutzman accepted it. I'm not sure, as I stated a minute ago, what happened between then and now. Do you have a position regarding Mr. Marvin's request for a competency evaluation?
I'm not able to take a position on competency at this time. I was appointed to this afternoon. I've got to meet with Miss Anthony before I can speak on it.
All right. I'm denying the motion to amend or change the bond.
And the only further request I have, Your Honor, is that this court review the video of the arraignment.
As I said, I'm not worried about that arraignment. I'm worried about the one I just did.
I understand.
So I'll say I would set a $10,000 cash or surety bond based on the conduct, based on the fact that she was on a felony bond and had pled guilty 5 days before, based on the fact that someone had a broken collarbone. If you want, I will set bond today.
Well, I might end up with a similar objection to this arraignment, but I would note that the conduct here was much different from the corrections officers.
All right. Well, 10,000 cash or surety with the same conditions. Greatly against the public interest to put this young woman out on the street, and it's against her interest. There's not a petition for hospitalization. She's on a personal recognizance bond in the circuit court. And if I were to grant your motion, she would be standing on the front steps of the jail in the condition that she's presently in. And I'm not willing to do that.
You won't believe the chaos that erupted in this courtroom. Janelle Anthony, facing serious assault charges and allegations of racially motivated hate speech, walked in that day with a level of tension that was palpable the moment she stepped through the doors. What should have been a standard arraignment turned into an extraordinary display of defiance, fear, and complete emotional breakdown. From the very start, it was clear that this was going to be anything but routine. The judge attempted to call the proceedings to order, but every word seemed to trigger a storm of reactions from Anthony. She shouted, interrupted, and became increasingly agitated as the mention of jail came up, each reaction more intense than the last. Her attorney struggled to explain her behavior to the court, pointing out concerns about her mental health, and questioning whether she was under the influence of substances at the time. Methamphetamine was suggested, and the court could see how it might be contributing to the volatility in her actions. At times, it was difficult to determine if her outbursts were purely psychological, purely drug-induced, or a combination of both. Regardless, the tension in the courtroom was undeniable, and everyone could feel it. The charges she faced were serious. Assault with intent to commit great bodily harm, resisting a police officer, ethnic intimidation, and simple assault and battery, all of these loomed over the room as Antony's unpredictable behavior escalated. Witnesses had recounted the incident, a violent attack where a woman's collarbone was broken, accompanied by racially charged language, leaving the victim in shock. The courtroom, which is normally a place of careful order and procedure, felt like it was teetering on the edge of chaos. As the hearing progressed, the judge struggled to maintain control, but he did so with an awareness that this was not just about law, it was about public safety, the defendant's mental state, and the complexity of handling someone in crisis. Antony's attorney raised multiple concerns, citing potential coercion during her arrest, and questioning whether all the proper procedures had been followed. They requested a bond review, seeking leniency based on her mental state, but the judge remained firm, emphasizing the severity of the charges and the need to protect the public. There was a discussion about competency, a critical factor in this case. Clearly, there were significant concerns about whether Antony could understand the proceedings, communicate effectively with her attorney, or even comprehend the charges against her. Competency evaluations were considered, but the court was also aware that such evaluations could delay justice significantly. Despite these delays, the priority remained safety, for the public, for Antony herself, and for the integrity of the court system. Every outburst, every interruption, and every shouted comment added to the tension, and the courtroom became a stage for the complex interplay between law, mental health, and human emotion. It was impossible to look away, as each moment revealed more about Antony's mental state and the challenges faced by the justice system. The judge expressed concern not only about her behavior but also about the availability of adequate mental health care within the jail system. This case highlighted the reality that the legal system often encounters defendants whose mental health needs are severe, and who require more than just standard incarceration procedures. As Antony continued to resist, argue, and protest, the court maintained its focus on order, fairness, and public safety. The judge's decisions, including the denial of a reduced bond, reflected a careful balancing act between compassion and accountability. Every ruling, every comment, and every tense pause underscored the seriousness of the proceedings. Observers could not help but note the difference between the courtroom as a place of law and the courtroom as a place where human fragility and disorder can collide dramatically. Throughout the hearing, Antony's behavior remained erratic. Her attorney continued to interject on her behalf, emphasizing her need for support and proper evaluation. The tension grew as the court wrestled with questions about mental competency, drug influence, and the potential risk to the public if she were released. It was clear that this case was about more than just the charges. It was a study in human behavior under extreme pressure, and a reminder of the limitations and responsibilities of the legal system. By the time the hearing drew to a close, the courtroom had witnessed a full spectrum of human emotion: anger, fear, confusion, and defiance. Antony's actions, combined with the judge's careful management and the attorney's advocacy, created a courtroom drama that was intense, disturbing, and impossible to forget. It showcased the intersection of crime, mental health, and justice in a way that few cases ever do. Every person present left with a vivid memory of how quickly order can unravel, and how complex it is to navigate situations where mental illness and criminal behavior collide. This hearing stands as a stark reminder of the challenges faced by the justice system when dealing with defendants who are unpredictable, mentally unstable, or under the influence of substances. It is a case study in the limits of control, the importance of mental health evaluations, and the immense responsibility placed on judges, attorneys, and law enforcement alike. The courtroom became a lens into human behavior at its most raw, exposing how fragile the boundary is between order and chaos, law and disorder, justice and compassion. In the end, this case left an indelible mark, not just on those present in the courtroom, but on anyone who watches the proceedings unfold. Janelle Anthony's chaotic arraignment is a powerful, unforgettable look at what happens when the legal system meets extreme human behavior. It is tense, emotional, and dramatic, offering a rare glimpse into the challenges of ensuring justice, protecting the public, and addressing the complex realities of mental health in the criminal justice system.
About shoplifting or running a stop sign. She is accused of seriously injuring someone, and there's a public protection interest here and an interest to protect her. And I had this discussion with the sheriff yesterday, acting Sheriff Bingaman. Our jail is the largest mental health facility in St. Joe County. Of the 93 people in there, probably about 40 of them have mental health problems. Some of them are quite acute, and she certainly is. So she's connected to Pivotal. She is in a position where she can't harm anybody. I don't know if Pivotal would petition for hospitalization. They could do a police petition, or someone could petition or hospitalize her. As you all know, once you ask for a competency evaluation, it takes a long time to get there. Mary Finney was in jail for like 400 days before she got her competency evaluation, and she's not competent. So at any rate, the bond is set at $10,000 cash or surety with same conditions. The motion to transfer from jail, St. Joe County Jail, is denied if there's additional evidence presented that she's unsafe or being unfairly treated at the jail. But she's just going to take her current problems to whatever jail I put her in. There is an option that somebody could petition for hospitalization. Mr. Marvin's motion for competency evaluation, I'm going to take that under advisement. Ms. Anthony is set for a pre-exam conference for October 15th. Anytime before then and now, we can review it. She is working with mental health. I'd like some input from them. She's been like this for 4 days. I don't know that she's instantaneously going to go into remission. I don't know enough about what's going on, but obviously what we all saw certainly begs for a competency evaluation. But Mr. Marvin, I think you made it in good faith. I'll take it under consideration. We can review it again between now and October 15th. And I'd like some input from CMH. Also, Judge Stutzman's going to have a problem. Someone from the Department of Corrections is going to be tasked with doing a pre-sentence investigation report on the case that she pled to, and thinking of a sentence on November 1st.
That could very well result in a report of competency concern.
Yes, he has the same problem I do. So perhaps if there's going to be a competency petition, it could be done in both files. So, Mr. Truckee, you are doing your job that you're appointed to do, to look out for the interests of your clients, but I don't think it's in the best interest of the public or her to grant your motion. We can certainly revisit it. And I'll revisit your motion to move her to a different jail.